our website. Zoom captioning is available. To enable, select Live Transcripts at the bottom of your Zoom screen, then select Enable Auto Transcription. Thank you.
Can we do roll call if we haven't?
Yeah. Connolly?
Here.
Gonzalez?
Here.
King?
Here.
Judge Klein?
Here.
Pryor?
Here.
Stalker?
Here.
Vulcan?
Here.
That's 7 present. We have quorum, and I'll go on to advisors. Justice Rodriguez?
Here.
Thank you. Judge Wayne Gutierrez? Not present. And then for liaisons, Selena Copeland?
Present.
Lauren Klein?
Here.
Melanie Snyder?
I'm Nicole. I'm here on Melanie's behalf, on the JCC behalf. Hi.
Thank you, Nicole.
Thank you.
And I'll make note of save our staff. We have quorum.
Thank you so much. We'll move on to public comment. In the interest of time, I would ask that we limit every public comment to 3 minutes. I would also ask that you please focus your comments on items that are on the agenda or relate to matters that are within this committee's jurisdiction. As a reminder, this is the Grant Eligibility Subcommittee. And so with that, we'll move on to see if there's anyone for public comment.
Yes, we have one hand raised.
Okay.
And I'm allowing them to speak.
Good afternoon, all members. My name is Kai On from Sacramento. Political power is controlling State Bar of California, Chief Justice, and Attorney General not to investigate Sacramento DA office and SPD, make up a story that fake killer Mr. Jung So Fong hit and run kill my father Woon Kong on. DA case number 99F08735. I went to governor's office in Sacramento, but governor's office doesn't take any action. How a state government allows political power to control the government, law enforcement, and justice system to commit obstruction of justice activity. It needs all members of State Bar Board of Trustees and all members of all State Bar Committee members to speak out and notify California Senate and Assembly to look into the issue. Someone is trying to control State Bar of California to cover up a scandal. Please help to uphold justice. Thank you for all your time. Thank you.
Thank you. Anyone else?
Yes, I've allowed the next person to speak. Monica Glicken.
Hello, I'm so sorry. I'm having trouble. I can't seem to, is the cameras, it looks like I can only do audio. Is that right?
That's correct.
Okay. Hello, everybody on the commission. My name is Monica Glicken. I'm the CEO, Executive Director of Public Law Center. Our request for an audit extension is under consideration today under item, I think, 4.2. I just briefly wanted to make a few comments in support of our request. As the staff noted, this is our 4th request for an extension in 4 years, and in some years we did have extraordinary circumstances found by the staff. I did want to note that we experienced a complete leadership transition, CEO, CFO, everybody, in 2023, and that also happened to be the first year of our organization ever having to do a single audit. which was a great learning experience, let's say. And I just wanted to assure the commission that we do take this very seriously. We really have been working hard to update and upgrade our financial processes and tools. We are just running into infrastructure problems. We are looking to expand our finance department staffing, which the changes we're planning on making will free up, make the daily workload more efficient so that we can have more thorough quarterly review, and which would in turn reduce the amount of time that's needed for year-end review and adjustments. We are also discussing with the finance committee perhaps shifting to an off-calendar fiscal year. That's been our other difficulty in completing our audit in time since we're on the calendar year. And we also just switched at the request of our audit committee to new auditors for the first time in over a decade. This is their first year working with us. Obviously, there's been a lot of learnings, but already we can see that it'll be more efficient working with them next year. So we do truly believe that we will not be repeating this request in future years, and I thank you for your time.
Thank you. Anyone else? Oh, there you go.
Yes, hello. Are you guys able to hear me?
We can hear you.
Yes.
Yes.
Thank you very much. My name is Annabelle Sanchez. I'm calling actually on behalf of Community Lawyers Incorporated. In the recommendation for today's decision, one of the things that I would like the commission to take into consideration is that CLI is one of 3 legal services organizations in Compton. Just in 2026, we have been able to serve already 54 members of the community. Our 2026 budget includes IOLTA and EAF funding. That staffs a part-time attorney, and it also staffs a portion of a paralegal's salary. So in consideration for the recommendations and the decisions that the commission will make today, I do want the commission to just take into consideration the needs of our community in Compton, how scarce legal services are in Compton, and really all of the work that CLI does for the community in Compton. Taking away the funding for CLI really is a disservice for our community and already the scarcity of resources that we have there. I want to thank the commissioners and just all of the staff from the State Bar that has provided, recommendations for us. I've said this before, I'll repeat it again. The recommendations that were made resulted in us changing our policies, not only changing our policies, but implementing our policies. Our policies that we currently have, that we've shared with the commission, have been implemented, and we're currently working within those policies at that time. Thank you.
Thank you.
Hi, good afternoon, everyone. My name is Nancy Alva-Viatora. I'm one of the part-time staff attorneys at Community Lawyers, Inc. And following up on the comment that Annabelle Sanchez just made, I just wanted to provide a brief case that I've worked on thanks to the funding we've received. And it is a divorce case for a gentleman who's permanently disabled. He has suffered several strokes, and without our assistance, without the funding that we've received, we wouldn't be able to assist him in his divorce that has been ongoing. He has difficulty speaking, so our ability to attend hearings on his behalf and be able to advocate for him have been tremendous. And so thank you so much for the continuous support, and hopefully we get the funding to continue to assist the people and the community members of Compton and the greater Los Angeles area. Thank you.
That was the last person with public comment.
Thank you so much. We'll move on to the chair's report. So I'll just take this time to welcome everyone. Thank you all for your patience as I sorted out my technical difficulties to join. Just quickly remind everyone and those on the call, the role of the Grant Eligibility and Support Committee is to ensure comprehensive oversight and support of grantee compliance across all Legal Services Trust Fund Commission grant programs while maintaining consistent standards and promoting accountability. We have a few important items to address today. First, approving IOLTA and EAF audit extension requests. Extensions after the application deadline, which was May 15th, are available to current grantees only and require a showing of extraordinary circumstances or approval with conditions. Per its recently updated charter, GES can approve these requests, but would send any with which it disagrees to the full Trust Fund Commission. Number two, recommending approval of late IOLTA and EAF applications, if any. Recommending to the Legal Services Trust Fund Commission that it delegate authority to GES again this year to approve the 2026 Care Court Awards to support centers and other entities and year two amounts for QLSPs and counties. Making a recommendation with respect to Community Lawyers, Inc. And their 2026 awards eligibility. This recommendation is coming from the working group that conducted an eligibility review conference with CLI in February. Our standing quarterly approval of timely budget modification requests, budget deviations, if any, and late carryover requests. And finally, I also wanted to report back on staff, Judge Rossi's and my work with the Center for Human Rights and Constitutional Law. As you might recall, the executive committee exercised delegated authority to place conditions on the center's 2026 grants following some serious findings from its site visit last fall. These conditions had a deadline of April 15th, 2026. One condition that is still pending and given a required timeline in the State Bar rules is whether their follow-up visit on March 17th was clean with respect to internal control fiscal findings. Staff issued the monitoring report for that visit, and the center has until June 26th to provide a response. Both Judge Rossi and I attended part of that visit, and staff has consulted with us on the findings. At this point, we'll wait for the center to reply before presenting any further recommendations. So I want to provide that update. Dwan, for staff, do you have anything you want to share with the group?
Sure. I just have two updates. So I think you saw by way of email. Chris McConkey, who was the committee coordinator for this particular committee, his last day with the State Bar was last Wednesday. So we really miss him, and I just want to acknowledge and take a moment to kind of thank him for all his contributions, even though he's not here. So in the interim, while we wait to kind of hire our new program manager, I'm going to be the committee coordinator, helping Jason with today's meeting. And then for the next couple committee meetings, as we go into kind of IOLTA and EF application review, Erica Carroll will be the committee coordinator and helping Jason. And Erica, as you all might remember, has ran the IOLTA and EF application review process before, so she'll be sliding in pretty seamlessly. The other update that I want to report back is now the IOLTA and EF applications have been due. The staff have done a preliminary sweep. And we do anticipate a number of eligibility review conferences for this cycle, a few with 2 new programs, and then there are a handful with existing programs. It's actually very serious compliance issues. So it's going to be a pretty heavy cycle, a lot of analysis, and we hope that you'll be able to make availability to kind of join the eligibility review conferences, because there are quite a number of them this year. So with that, I'll turn it back over to you, Jason.
All right, great. Next item is the approval of the January 21, 2026 open session minutes. At this time, assuming everyone has had an opportunity to review those minutes, I would invite a motion to approve.
So moved.
Second.
That's King, then Klein for first and second. Can we do a roll call vote?
Connolly,
Yes.
Gonzalez,
Yes.
King,
Yes.
Judge Klein,
Yes.
Pryor,
Yes.
Stalker,
Yes.
and Galkin.
Yes.
That's 7 yeses, 0 noes. Motion passes.
Wonderful. All right, we'll move on to our business items, starting with 4.1, approval of 2027 interest on lawyers, trust accounts, and equal access fund grant audit extension requests. I believe we have Erica Carroll to present on that.
Shannon, if you could promote me so I could share my screen, please. Sorry, I was just rejoining the meeting so I can share my screen with the PowerPoint. Thanks for your patience. Good afternoon, everybody. That's on.
You're on, you're sharing, but it looks like you're stuck on non-presentation.
You know, this happened to me last week. It just takes like 10 seconds if you can just.
Oh, so just do it.
Yeah.
No problem.
It happened to me before me. Or you can just share the screen. That's what I did last.
There it is.
Great. I'll have more patience next
Yeah.
time. Thank you. So happy to be speaking with you about our 2027 IOLTA EAF audit extension request today. So just a little bit of background and an overview. Audited financial statements are a required part of our annual interest on lawyers' trust accounts and equal access fund application process. As part of state bar rules, the annual deadline on these documents is May 1st. However, there is a bit of flexibility with that deadline built into the rules that staff has discretion to grant an extension to the application deadline, which usually falls a little bit later than the audit deadline. This year it was May 15th, so staff had a 2-week window to offer audit extensions to grantees who needed them a little more time to submit their final audited financial statements. And in most cases, we did approve. We received a number of requests through May 15th. Anything beyond the application deadline, staff no longer has discretion to grant that extension, and we bring it to the GES committee for consideration. Under the rules, the committee can grant an extension on a showing of extraordinary circumstances requiring it. Otherwise, the committee has the opportunity to accept it with conditions, or of course to deny the late submission of the audit. So when no extraordinary circumstances are present, the committee has options about what conditions it might want to impose. And so with this year's set of audit extension requests, we had 3 that went beyond the May 15th deadline. So the first one that was referenced in the memo that was part of your materials was UFW Foundation. I included them on this PowerPoint just because they were in the memo, but this organization actually met the May 15th deadline. They were able to submit earlier than they thought they would, and so we're going to exclude them from consideration for today's meeting. And then we have Public Law Center. They cited, you heard from their executive director in public comment, but they cited that they had a new audit firm which extended their timeline for finalizing their single audit from their 2024 fiscal year, which then caused subsequent delays with addressing their 2025 audit. And so they are requesting to submit by June 30th their audit. And Eviction Defense Collaborative also is seeking an audit extension, and they reported that they had significant delays due to the passing of their executive director early in their fiscal year of last year, at a time when they had recently undertaken significant changes to their fiscal processes, and were starting to work with outside vendors on some of those. And so again, it was a bit of a cascading effect impacting their ability to get everything together to work with their auditors. So they are requesting a submission date of July 15th for their audit. So in the case of Public Law Center, staff is recommending that the GES committee accept or approve the extension date to June 30th with a recommendation that the committee instructs staff to send a letter to Public Law Center's Board of Directors regarding the importance of deadlines and potential consequences of future noncompliance. The reason for this recommendation was that staff didn't necessarily feel that the explanation this year rose to the level of extraordinary circumstances, coupled with the fact that this was the 4th year in a row that the organization has needed an extension well past the application deadline. And so that is the recommendation as far as Public Law Center. And then Eviction Defense Collaborative, staff is recommending approval of their extension date for their audit. And staff felt that the circumstances surrounding that were extraordinary, and so it's just recommending approval with no conditions attached to it. So that, I see Selena has her hand raised. I am putting the resolution up on the screen, but happy to answer questions or any discussion before we reach them.
Selena, would you like to go?
Sure. I was making sure I wasn't breaking into on the discussion of commissioners. I had a question because this is looking so much better than past years where we'd have like 8 organizations with late audits. Monica mentioned that their fiscal year is actually a calendar year. Of those organizations that often have late audits, are they mostly on calendar years? Because I would say it's more difficult for organizations that end on December 31st versus organizations that end on June 30th. So the question is, how frequently is a challenge related to the fiscal year timing?
Yeah, for this year, I don't have the exact numbers for you, but I would say historically that has often been the challenge, is the timing of the fiscal year itself, and that it is more likely to see audit delays for organizations that have that shorter turnaround time with the end of the calendar year. December 31st, only having about, those 5 months to get something in versus over basically almost a year for organizations that might have a July to June fiscal year. So that is definitely a contributing factor for many organizations. That's not always the case, but it does come up a lot.
Any other comments or questions? All right, hearing and seeing none, I would invite a motion related to the proposed resolution on the screen right now.
So moved.
That was Ms. Gonzalez, I think.
Yeah.
I second prior.
All right, roll call vote, please.
Connolly,
Yes.
Gonzalez,
Yes.
King,
Yes.
Judge Klein,
Yes.
Pryor,
Yes.
Stalker,
Yes.
Galkin.
Yes.
That's 7 yeses, 0 nos, motion passes.
Erica's got her hand up, so.
So I just had a quick thing. This is, I just saw in the memo about UFW and some concerns because they were kind of new. I understand that they got their thing in on time. I'm just curious if staff still thinks there ought to be any kind of heads up about the importance of deadlines, given that they're kind of a new entity. If not, no problem, but I just wanted to check in on that.
Yes, thanks. We sort of informally have had that communication with them. When they first asked for an audit extension, we sort of revisited the governing authorities with them, and that I think is actually what prompted them to do their utmost to get it in on time. So I think in a way that has been communicated, even though it wasn't a formal letter.
Perfect. Okay, thanks. I just wanted to check on that. Thank you.
All right, well, moving on to 4.2, we have approval of recommendations regarding late 2027 IOLTA and EAF grant applications. And I think, Erica, this is still your floor.
Yes, thank you. So I'm just gonna, yeah, okay. So yes, 4.2, approval of recommendations regarding late grant application submissions for 2027 IOLTA and EAF funding. So background on this, our IOLTA and our Equal Access Fund grant applications were due last Friday, May 15th at 5 p.m. Again, under the state bar rules, staff has some level of discretion to accept application materials that come in late. In this instance, we have 1 business day to accept after the application deadline, which so we treated the end of the day on Monday the 18th as that business day. After that date, the GES committee and ultimately the commission would have to determine whether to accept an application. Or in the instance that staff chooses not to accept an application and refers it to the committee for any reason, that would also be presented for your consideration. So we received 4 late applications that we're reporting out on today. 3 of them staff accepted because they came in. 2 of them were just within minutes after the deadline, and we think there was probably some technical delay or issue there. And then in one instance, it was received a few hours after the deadline, and the organization reported that they had been hoping to get their 990 form from 2025 to include, because this was the first year we've required that as part of the application, and they hadn't realized that initially. And so they wanted to be able to submit the complete application with that form once they got a hold of it. So staff accepted those late applications. The one that we're presenting today for consideration is from Wage Justice Center. That organization, they also submitted within 1 business day, but staff decided not to make a decision on whether to accept or not and to bring it to the committee because of other kind of surrounding circumstances regarding their lateness. So Wage Justice Center has had a series of late submissions of a variety of materials within the past year. So in the fall of 25, they were, I believe, about 10 days late with their budget proposal, which eventually the commission did find that they had demonstrated extraordinary circumstances. But at that time, the organization had represented that they were going to develop contingency plans to avoid other late submissions, and that they were essentially, alerted to the issue with that and would be avoiding it in the future. But we've also had all of their 2025 evaluations have come in late. So 2 of them were, I think, about 6 weeks late, and 1 of them was 4 weeks late. The organization reported it was due to changes or updates to their case management system causing the delay. And then now, most presently, they requested an audit extension to May 15th, which staff learned after the application was submitted that they actually didn't submit their audit. So their application is missing an audited financial statement. And then it was also, the application itself was late. We've reached out to Wage Justice Center to understand better about what's impacting their ability to submit on time in this particular instance. We haven't received a response from the organization yet this week. So I unfortunately can't report what the circumstances were that caused the delay, but the application was late and we are missing an audit for this application. And so we originally were planning to recommend that the committee recommend accepting the application with conditions, but now that we've become aware of the missing audit, the recommendation that we're actually going to make today is that you defer on accepting this application until we can learn more from the organization, and staff would recommend scheduling an eligibility review conference with them during the application review period instead. So what that would mean, practically speaking, is that we would hold the eligibility review conference and then bring this back to the committee to report out on the conference itself, as well as recommendations about whether to accept their application at one of the subsequent GES meetings this summer. So that's kind of the summary about Wage Justice Center. I drafted a different resolution that I can bring up than the one that's in the PowerPoint, given the new information that we learned about their audit. So shifting the recommendation to an eligibility review conference. But again, happy to answer questions or discuss this further before doing that.
Questions or discussion from anyone? Erica?
Thanks. I just wanted to check prior to this thing that happened in the fall, have there been other instances of any compliance issues with this entity?
No serious ones that I'm aware of. I think there have been here and there maybe some lateness on some materials, but not this sort of what we're recognizing essentially as a consistent pattern at this point. But it was more intermittent or sporadic, but just as any grantee has occasionally.
I think part of also the concern is they're a really small organization, and now we have reached out several times about, the application is pretty serious, and not to submit an audit on time is also pretty serious. So it's concerning that there's been no communication back to us.
And I guess I'm a little confused on the audit. So they have not submitted an audit. They've asked for an extension, but only to the May 15th. That's why we didn't address them in the last
Correct.
action. Okay.
My understanding is they requested an extension to May 15th, which was the application deadline, that they didn't provide a great amount of detail about the need for the extension, just that they needed a little more time. Staff granted that, but when we went to look at the actual application that was submitted, the documents that were included with the application were not, that it did not include the audited financial statement. We haven't heard from them about that, either requesting further extension or explaining why it's not included there. And we haven't been able to get in touch with them this week to kind of confirm any of that, given that it's been less than a week since the deadline. But we have reached out several times to try to be able to, provide more context and details, but we just don't have it at the moment.
They did upload something, right, Erica? But it was
a profit and loss statement for the 2025 fiscal year.
Required to do an audit if they're kind of small? I'm just curious.
If they're below $500,000 in gross corporate expenditures, they do have the option of submitting a reviewed financial statement, but it would still need to include things like their statement of functional expenses and the typical schedules that you would have in financial statements. So the profit and loss statement is unfortunately not sufficient.
So right now they're a little bit in the wind where we have an incomplete application and no audit, even though it's after May 15th.
Correct.
Thank you. I just got a little confused. So I appreciate the answering the information.
Anyone else? And if not, Erica, do you mind putting the updated resolution up for folks?
If this was the original. So the updated resolution is recommending that the committee defer on a recommendation about whether to accept this application, and that staff would then be scheduling an eligibility review conference with the organization that we would be inviting commissioners to take part in.
Okay. I'll invite a motion for this.
So moved. It's Bob.
I'll second.
All right, Stalker and King, and we'll do a roll call.
Connolly,
Yes.
Gonzalez,
Yes.
King,
Yes.
Judge Klein,
Yes.
Yes.
Right.
Yes.
Stalker,
Yes.
Falcon,
Yes.
7 yeses, 0 nos, motion passes.
Wonderful. Thank you, Erica.
Thank you.
Next, we have approval of recommendation to delegate authority to approve 2026 care court grants and amounts for county public defender offices. And I believe we have Lana here to present.
Hi. Yes, let me share my screen. Can everyone see this presentation?
It's coming
Okay.
here.
You can see it, sorry. Okay, great. Thank you. Yeah, hello, thank you for your time for having me today. My name's Lana Martin, and I'm a senior program analyst in the Office of Access and Inclusion. First, for context, the current Draft Budget Act of 2026 will require that the State Bar issue 2026 to 2027 Care Court Awards by July 1st, 2026. So to align this deadline with commission and subcommittee meeting schedules and to follow procedure consistent with last year, staff will recommend that the GES committee seek a delegation of authority from the commission to approve these awards. So I'll start with a brief summary of the program. The Community Assistance, Recovery, and Empowerment, or CARE Act, passed in 2023, and it created a new civil court program to support adults who live with specific serious mental health conditions. So under the CARE Act, a CARE respondent works with counsel, county behavioral health professionals, and the court to create a voluntary care agreement that connects them to treatment, medication, and other community services. And if these parties cannot reach a voluntary agreement, the court may order a care plan. So per the CARE Act, care courts must appoint qualified legal services projects to represent care respondents in CARE Act proceedings and matters related to care agreements and care plans. If respondents' counsel through a QLSP is not available, the court must appoint a public defender. So since 2023, each state fiscal year's budget act has provided that the Legal Services Trust Fund Commission administer funds to respondents' counsel. And the commission can also use care funds to fund support centers and other entities to provide training, support, and coordination for the Care Court Respondents Council. So the Budget Act of 2025 did introduce a different approach to structuring these awards and amounts for counties. It required issuing 3-year funding commitments to QLSPs and to counties. So in 2025, the commission requested 3-year proposals from QLSPs. And the 2025 care agreements for Respondents Council for both the QLSPs and the counties defined this 3-year funding commitment, which was 2025 to 2028, while providing funds for that 2025 to 2026 fiscal year. However, that Budget Act retained the 1-year award cycle for support centers. This is just helpful context for later. So the Draft Budget Act of 2026, which is Assembly Bill 1563, provides that 2nd year of care court funds for counties and those 4 QLSPs that have the 3-year funding commitment. And it also allows the commission to issue another cycle of 1-year awards to support centers or other entities for that training and technical assistance. All right, so on January 9th, the governor's office released that proposed budget for state fiscal year 2026-2027. It provides the same amount statewide that the Budget Act of 2025 provided for Care Court. So with the current Draft Budget Act, that's $15,750,000 that is anticipated to be allocated for representing respondents, and up to $787,500 of that can be awarded to support centers or other entities for that training and technical assistance. So as with the 25-26 funding cycle, any amounts left unawarded from the support center work can be shifted over to Respondents Council. And this funding period would begin July 1st, 2026 and end on January 1st, 2028. And that would be for both Respondents Council and support centers. So on May 14th, the May revision budget was released, and it did not indicate any changes to care funding. So on May 19th, the State Bar released the RFP and application just for support centers and other entities. with a deadline to submit proposals by June 8th. And the state legislature, of course, typically passes the Budget Act by June 15th, and the statewide allocation for care court in that final Budget Act will determine the amount that the State Bar can provide to Respondents Council and support centers. So as with the Budget Act of 2025, this year's Draft Budget Act has the same provision to make awards by July 1st. And while commission meetings are scheduled for May 29th and August 14th, the GES committee next meets on June 25th. So to prepare for issuing the 2026 CARE Awards, staff updated the request for proposals with only statutorily mandated updates and technical changes to prepare for that 26-27 funding cycle. This included seeking proposals only from support centers and other entities that provide training and technical assistance to Respondents Council. So during the month of June, after that application deadline of June 8th, the GES committee will review these proposals. The scoring team, comprised of 2 commissioners and 2 staff, will use the same procedure used in 2025 that created the 25-26 awards. And after the GES committee finalizes recommendations for support center awards, they will also form a recommendation for year 2 amounts for the counties and those 4 QLSPs that provide Respondents Council. And the 2026 CARE RFP describes using the same approach to distribute funds to each county as used in 2025. So that uses general population numbers to estimate funding for each county with funding floors built in to raise allocations for counties with smaller populations. So again, the Budget Act of 2026 will likely require that the Commission make CARE awards by July 1st, which is before the Commission's next scheduled meeting. So to comply with that likely requirement of the Budget Act, SABAR staff recommend that the GES committee seek this delegation of authority to finalize these awards and year 2 amounts at that next subcommittee meeting on June 25th. So I will provide the resolution on the screen and pause for any questions or discussion. No? All right. If we don't have any questions then, is there a motion to recommend delegating authority to GES to approve the 2026 CARE Awards and year 2 amounts for the counties and those 4 QLSPs?
I'll move.
I'll second.
Let's go ahead and do roll call.
I'm sorry, that was King moved and Connolly second?
You got it.
Thank you. Connolly?
Yes.
Gonzalez?
Yes.
King?
Yes.
Judge Klein?
Yes.
Pryor?
Yes.
Stalker?
Yes.
Galkin?
Yes.
7 yeses and 0 nos, motion passes.
All
Great.
right.
Thank you, Lana.
Thank you.
All right, moving on, we have the approval of recommendation regarding Community Lawyers Inc.'s 2026 IOLTA and EAF grant eligibility. I think Sylvia is joining. There she is to present on this. Sylvia, floor is yours.
Also, I invited Raul in case you may have questions for this item.
Okay.
Okay. All right. Thank you, everyone. Good afternoon. My name is Sylvia Nam. I am in the Office of Access Inclusion. I will be presenting item 4.4, approval of recommendation regarding Community Lawyers Inc.'s 2026 interest on lawyers' trust accounts and equal access grants, fund grants eligibility. The item follows CLI's off-cycle eligibility review conference, which took place on February 25th, 2026. At the last GES meeting in January, the committee voted to require that CLI undergo an ERC. That ERC working group consisted of Commissioners Eloina Gonzalez and Bob Stalker. I'll begin with a brief background on the organization and summarize the findings from the 2025 monitoring visit with the organization, which centered on serious program findings related to quality control, particularly supervision of volunteer attorneys and case management and oversight practices. I'll also provide an overview of the governing authorities underlying the working group's recommendation to terminate CLI's 2026 IOLTA EAF award for noncompliance with statutory and state bar requirements that govern quality control safeguards necessary to ensure safe and effective delivery of legal services. Specifically, the working group concluded that CLI continues to lack adequate and reliable quality control measures to address the core concerns identified during the monitoring visit, and that CLI's proposed supervisory practices remain inconsistent with the quality control procedures described in its 2026 IOLTA EAF application. A brief background on the organization. CLI is a qualified legal services project located in Compton, California, that primarily delivers services through pro bono clinics. It's one of the smaller programs funded by the Commission. According to its 2026 IOLTA EAF application, CLI reported approximately $229,000 in total organizational expenditures in 2024. The organization reported closing 330 cases in 2023, 480 cases in 2024, and 432 cases in 2025. CLI first received IOLTA and EAF funding in 2022. Its combined 2026 IOLTA and EAF award is approximately $62,000. Also, CLI operates with limited staffing. Going back to its 2026 application, nearly all staff were part-time, including its attorneys and executive director. The exception has been one full-time paralegal. The organization relies heavily on volunteer attorneys to provide advice and limited scope services in housing, immigration, family law, and special education. In 2024, 5 volunteers provided approximately 122 hours of service. Given the staffing and service delivery model, CLI's ability to provide safe and effective legal services depends heavily on reliable supervision, consistent case review, and other effective quality control safeguards. In September 2025, State Bar staff issued a monitoring report following CLI's 2025 monitoring visit. Although CLI described supervisory and quality control procedures in its 2026 application that, if implemented, could support adequate oversight, interviews indicated that these procedures were not consistently implemented in practice. Specifically, staff identified the absence of a routine or systematic process to observe, review, or timely assess the legal services that volunteer attorneys that legal services provided by volunteer attorneys. Interviews also indicated that volunteer attorneys were communicating with clients independently and operating outside the policies that governed its case management system. During the concluding conversation with the then executive director, that executive director acknowledged awareness of these issues and additionally reported that a volunteer attorney had referred out cases without CLI's authorization. Staff remained unclear what corrective measures, if any, had been implemented in response. Following issuance of that report, CLI reported a leadership transition in which its supervising attorney became the incoming executive director. As a result, attorney capacity available for supervision decreased from approximately 1.0 full-time FTEs across 3 attorneys to approximately 3/4 of an FTE across 2 attorneys. CLI submitted written responses to State Bar staff in November 2025, and staff subsequently met with the incoming executive director to provide technical assistance, discuss the monitoring findings, and support the organization's transition. However, staff remained concerned that CLI had not just demonstrated a viable plan for adequate supervision and quality control, or how such a plan could be implemented given its limited staffing structure and attorney capacity. Staff therefore requested additional clarification. The subsequent responses did not resolve staff concerns regarding consistent supervision, as well as the other issues that I mentioned. And so in January 2026, the GES committee voted to require CLI undergo an off-cycle ERC. The ERC took place in February of this year. CLI's executive director and program director attended on behalf of the organization. During that ERC, the working group focused on whether CLI had implemented adequate quality control safeguards consistent with the requirements of the IOLTA statute and state bar rules governing supervision, client protections, as well as quality control. The working group repeatedly asked CLI how it would ensure timely observation, evaluation, and review of legal services provided by volunteer attorneys, particularly given that the organization's limited staffing capacity and attorney capacity at that. In response, CLI explained that oversight would largely consist of the executive director or supervising attorney being physically present during clinics to overhear consultations. At the time of the ERC, that supervising attorney position remained vacant. CLI also reported hiring a part-time volunteer coordinator to provide outreach to volunteer attorneys. However, that role does not address the need for attorney supervision, case review, and legal oversight. After extensive discussion, the working group concluded that CLI did not demonstrate adequate quality control safeguards required under the trust fund program. So in this slide, it highlights the governing authority for the commission for commission action when a recipient is not in compliance with trust fund program requirements. Rule 3.661C7H authorizes the commission to terminate a grant for noncompliance with requirements or grant terms. The rule also establishes the compliance process. In this case, staff first identified its concerns through the monitoring report, issued that report, engaged in TA and follow-up, requested additional clarification, all before the matter was referred to this committee for further action. Again, the working group, after its ERC, concluded that the concerns identified regarding supervision and quality control were not resolved through these earlier efforts. And so the recommendation before the committee is prospective termination, meaning from this point onward, so not retroactive, of CLI's 2026 IOLTA and EAF awards pursuant to this rule.
Sylvia, let me clarify something about the perspective. This committee would still need to pass along the recommendation to the commission, and at that time, if the commission then agrees with the recommendation, then it would be termination from that point. So it would literally be today.
Yeah, thank you for that clarification. So the resolution states that the committee would recommend to the commission to approve the recommendation, and the way that we have it scheduled, it wouldn't go up for the full commission meeting until August. So in about 3 months' time. So the recommendation is grounded in statute, rules, and grant requirements related to supervision and quality control safeguards. Here in this slide, you'll see that there are a number of governing authorities related to quality control, and these are the governing authorities that underlie the working group's recommendation. Collectively, the authorities establish that organizations receiving trust fund program funding must maintain adequate quality control procedures, supervisory systems, and client protections. They also require organizations to accurately represent their supervisory and quality control procedures in their funding application and to maintain those safeguards in practice. Okay, so this is on quality control. So under the IOLTA statute, an organization seeking funding must not only provide free civil legal services to low-income Californians, they must also maintain quality control procedures approved by the State Bar. The statute further requires grantees to maintain quality service and professional standards as an ongoing condition of funding. The provision establishes that quality control and supervision are requirements of the program and not merely administrative best practices. State Bar Rule 3.661D explains that quality control standards function as safeguards to ensure that legal services are delivered effectively, professionally, and in a manner that protects clients. The rule also emphasizes that these safeguards ensure organizations are effectively managed and maintain adequate governance and oversight. The Legal Services Trust Fund Commission relies on the ABA standards for the provision of civil legal aid as guidance in evaluating whether organizations maintain quality service and professional standards in practice. Rule 3.680E2 requires applicants to describe in their annual funding application both their quality control procedures and how those procedures are implemented in practice. This includes information regarding supervisory structures, internal review procedures, case oversight, staffing, and related professional standards. So one of the concerns here was the disconnect between the supervisory structure CLI described in its application to the Commission and the practices identified during the monitoring visit as well as in the ERC. Rule 3.681C through D identifies specific client protection and oversight requirements that recipients must maintain as a condition of funding. And so as you can see from this list, they go from staff and volunteer supervision to appropriate case management systems. And so these safeguards are intended to ensure high quality legal services, client protections as conditions of funding from the Commission. This is a slide on General Grant Provision 2.04.4, which requires that statements and representations made in the funding application remain accurate and material unchanged throughout the grant term. During the monitoring visit, as well as the ERC, staff and the working group identified significant inconsistencies between the practices on supervision and quality control described in the organization's application and the practices in operation. And so these inconsistencies also contributed to the working group's concerns regarding compliance with requirements. I alluded to ABA standards earlier, but here are the ABA standards that reinforce the importance of supervision and review of delivery of civil legal services, specifically Standard 6.4 that explains that organizations are responsible for supervising the work of practitioners to ensure clients receive high quality representation or assistance. And Standard 6.5 that further explains that organizations should review legal assistance and representation to ensure quality service and to identify areas requiring training or additional support. And so again, the concerns identified during the eligibility review conference relate directly to these issues of supervision and case review, as well as general oversight when it comes to volunteer attorneys. So the resolution before the committee would recommend to the broader commission to terminate CLI's 2026 IOLTA and EAF awards for non-compliance with statutory and state bar requirements governing the trust fund program, including requirements related to quality control standards, procedures, and client protections. And I'm happy to take questions as well as invite the working group if they have any additional comments or feedback.
So I'm the chair, so I'll call myself. So I guess my question is, assuming the Trust Fund Commission follows through with this, what are the implications on overall eligibility for CLI? And I have a particular interest in overall eligibility and the implications on such a determination for any carryover funds that might be still remaining unspent from prior to the 2026 awards. Because it seems to me, based on all of the information you shared and what was from the review, that the concern, the proximate concern here is persisting and ongoing. So I guess my question would be, if there are remaining unspent funds that are carryover, I guess that's a question. And if there are, should we be similarly concerned about those remaining funds being with CLI rather than returning or something for the same reasons that we're talking about the IOLTA and EAF awards from 2026?
I will have to get in touch with my fiscal colleague to see what their expenditure reports look like thus far. But as I mentioned, their 2026 award is approximately $62,000. And part of the working group's recommendation for it to be not retroactive but prospective was to figure out exactly how much in unspent funds there were, because by the time this comes up for consideration at the commission meeting, Q3 payments would have gone out. And so I do think that it's something that should be discussed completely My fiscal colleague says that for 2025, they fully spent all 2025 IOLTA EAF and additional EAF funding as of the end of the calendar year of 2025. So it remains, so the assumption is they probably have some funding for 2026, but I'd have to confirm those figures.
Understood. Thank you.
Right, can I speak to kind of a little bit the practicalities, and this is why I invited Raul to join. So by the time the commission goes to make this determination, as Sylvia said, we've already issued Q3. We may be in the process of issuing Q4, so we wouldn't do anything kind of out of schedule unless the commission kind of makes a determination, right? So there's the one issue of like the payment, but as you all know, sometimes programs spend it at a different cadence than what they budgeted for. So we actually won't know. We do not right now know how much funding that they will spend by the time that we have made that determination. I mean, you know, we can presume, right, if it's 3 quarters, they may have something left of that 4th quarter. And if the commission kind of approves that recommendation, then what would happen is we would ask them to at that time kind of halt services and moving forward, not spend the remainder of our funding, and they would need to return the remainder of the funding year. But at this time, we don't know how much that is. And it's a very small amount. I think one idea, and I wasn't on this working group, but I think the idea was they have already spent a lot of this money. So we didn't want to have to call back the money that's already been spent. But since there are really serious concerns about public protection and adequate supervision, that if the commission makes a determination that it would make sense moving forward for them to not use our funding.
And then just to clarify, their Q1, Q2 semi-annual report won't be due until the end of July. So, yeah, we want to have figures for another 2 months, more than 2 months.
But there is a related, their 2027 application. Obviously, everybody had to submit last week, so we will be reviewing it. But there is a requirement for the new requirement about submitting a pre-application. And Sylvia, can you walk through whether they needed to submit a pre-application or they're still on for like a regular review? Kind of how did this recommendation kind of intersect with their 2027 eligibility? Because I think that was probably the related question that Jason had.
Yes. So for 2027 application for this funding cycle, if you are an unfunded applicant, that you are required or it was like heavily recommended that we insisted that you submit a pre-app, but because CLI is a funded applicant, that provision, that expectation or that requirement does not extend to them. So they did submit their 2027 IOLTA application that is currently under staff review along with the other applications in the queue. So we won't know basically until we return to this committee with staff recommendations.
Got it. Erica.
Thanks. I have a couple of questions. First, I think, Sylvia, you said our recommendation wouldn't be taken up by the full trust fund commission until the August meeting, and I'm a little confused as to why we'd wait until August and not do it in the May. I guess because it's too close in time to do it for the May 29th meeting. Is that why?
There were a couple of factors, and I don't want to speak directly on behalf of the working group, but I do think that it was just to give the organization enough time to respond to our touch points, our multiple touch points, to respond to both the monitoring visit findings, and then not turn it around so quickly within less than a week's time, or because the next commission meeting is in 8 days. To let the committee really have a robust discussion. And in terms of timing, the agenda item for the full commission meeting, I think, was due yesterday. And so not presuppose the decision of this committee and to allow for this committee to really take into consideration the working group's recommendation.
I will add, right now the plan is to go in August, but we do have, again, I don't want to underscore, very serious other compliance issues that may necessitate a earlier commission meeting. So if that happens in the summertime, then we will bundle this this topic with the other ones. And then, so it may go earlier than August.
Okay. I uh, just, I understand the timing with the agenda and stuff, but it feels a little odd to say this is like a real risk to the public, but we're gonna like not take it up until August. The the other question is like um I assume this is maybe not something that we can like have an issue, talk about here, but like I guess are there other, because I assume there's some other organizations that also rely on a fair amount of pro bono attorneys. Do we have sort of a model that like of like what we're expecting of them as far as the supervision that we could like point to? I'm not opposed to the recommendation. I just want to, I'm also like prefer to help organizations continue to provide service. So that's to the extent that we can help them get back on the right track longer term. Is there, I assume this went through with the working group, the ERC, et cetera. But like, is there some model that we can point to as far as like, this is what we're expecting?
The monitoring report, so staff in the monitoring report that was shared with CLA back in September outlined ways that they could address the supervisory concerns that were identified in the monitoring visit.
Okay, great.
Also, its application, in order to be deemed eligible for funding, the quality control procedures in an application have to pass muster according to those ABA guidelines that are the quality control guidelines that the commission takes up when making those initial threshold eligibility determinations. And so the application that was submitted said one thing when it came to quality control procedures and supervision. The monitoring visit found something inconsistent with what was presented in the application. And then the monitoring visit outlined, you'll see it under finding 1, but there's a number of bullet points where staff made suggestions at the discretion of the CLI's leadership and board to then institute a plan that both reflected what they said they were going to do, but also the standards as it reflects that that are required in statute as well as the rules. And then that timeline also were multiple touch points to provide technical assistance and support to ensure that the need for an effective supervisory and oversight and case management plan was clear. And so there were multiple efforts to help the organization institute a viable plan.
It's a little bit, are they sort of and maybe this is in the paperwork, and I apologize if I didn't know this. But I see that they've been around since 2005. Is this like a new development, or are they like a fairly new applicant? I'm just kind of curious kind of what the history has been.
So they first applied for 2020. They applied in the 2021 year, and there was an ERC then. They did not submit a financial, not the audit, but the financial statement, the necessary paperwork in order to be deemed eligible. But the working group then identified how leanly staffed the organization was. In 2022, when they reapplied, they also had another ERC, and the working group also raised to the organization concerns around quality control procedures as related to a very limited staffing structure. And the organization assured the working group and the commission that it had the capacity to oversee and supervise the services that were provided to CLI's clients. And so those assurances at that time were accepted. But I think that this question around supervision and being leanly staffed had been on the commission's radar since the organization first applied in 2021.
I'll shed a little bit of light on that. At the time when they first applied, staff did have serious concerns, and there was a split opinion in that ERC with the commissioners and the staff. And so we did fund them. And I mean, they're a very small organization, so it's difficult. But I think to your question about there are like rules in terms of ratio supervisions, if that's what you're asking. I mean, we do look at kind of the totality, the circumstances and the types of cases that are coming in, you know, who's working on matters and stuff, so like that. So there's not clear guidance, but we do have, I mean, there are a number of we have a number of very excellent like organizations that provide pro bono. So there are model organizations out there that, again, we're happy to kind of connect them with, have them talk. But in terms of like a baseline, like what's like a safe harbor, we don't have anything like that.
No, that makes a lot of sense. And my question was not to indicate that I have any doubts about the work or the recommendations. I was just, trying to think if they want to get back onto the right thing. If, there was some organization that was illustrative. I appreciate the historical context. I mean, all this makes a lot of sense to me. I just wanted to ask a couple questions. Thank you.
All right, if that covers our questions, we do have a proposed resolution. Do we have anyone willing to make the motion?
I will move.
I second.
That's Stalker and then Pryor, and we'll do a roll call.
Connolly,
Yes.
Gonzalez,
Yes.
King,
Yes.
Judge Klein,
Yes.
Pryor,
Yes.
Stalker,
Yes.
Galkin.
Yes.
7 yeses, 0 noes, motion passes.
Thank you so much. Thank you, Sylvia.
Thank you.
I believe we're moving on to 4.5, approval of 2026 Q1 budget modification request. I believe we have Esteban here.
Yes,
Him?
thank you so much.
Of course.
1 second, let me move this. All right. Okay, good afternoon, Chair and members of the committee. My name is Esteban Cano Gutierrez. I'm a Senior Financial Analyst with the Office of Access and Inclusion. And today I'm presenting item 405, approval of the 2026 Q1 budget modification requests. So State Bar Rule 3.6A6F3 allows the Commission or a committee of its members to approve budget modification requests that exceed 25% of the total grant award. In addition, the general grant provisions require LSTFC review when a budget modification will increase non-personnel or administrative costs above 25% of the total budget. For Q1 of 2026, staff received 4 budget modification requests requiring GES committee review. These requests were brought to the committee because they involve deviations over 25%, changes to approved services or deliverables, and or spending ratios outside required ranges. Staff recommends approval of all 4 requests, and staff also approved 5 additional requests with deviations between 10 and 25%. These are included in the presentation for informational purposes. So Table 1 begins with 2 of the requests requiring committee approval. First, we have Council for Justice, who is requesting to shift 2026 EIF funds from its Veterans Project to its Immigration Legal Assistance Project after the Veterans Project lost its supervising attorney. The revised budget will support attorney and paralegal time for approximately 20 to 25 immigration clients. Next, we have Law Foundation of Silicon Valley, who is requesting a scope expansion for its 2026 EIF grant. Although there is no budget deviation, that's why it's 0% there. The request affects more than 25% of approved services and deliverables. The change will allow EIF funds to support the children and youth programs and pro bono program after the organization receive unexpected housing funds from another funding source. Next, we have Senior Advocacy Network, who is requesting to revise its 2026 IOLTA budget to align with actual expenditures. The organization relied more heavily on IOLTA funds due to delays with the College FA supplemental funding and the closeout of the consumer debt grant. Finally, we have UC Davis School of Law Legal Clinics, They are requesting to shift 2025 additional EIF funds from staff line items to non-personnel costs. Although the deviation is only 5.33%, the revised spending ratios fall outside the required ranges, which is why the request requires committee review. Staff have reviewed all these requests and we recommend approval. Table 2 summarize the request staff approved administratively. These requests were from California Rural Legal Assistance, Coalition of California Welfare Right Organizations, Legal Aid Society of San Diego, and Senior Citizens Legal Services, which is in the next slide. And one additional staff approved request that it's included in the memo, but not in the presentation. Each request had a deviation between 10 to 25% of the award, and it was within a staff approval authority. In general, this is the Senior Citizens Legal Services one. In general, these changes were intended to align budgets with actual expenditures or staffing needs or accounting classifications. Staff determined that the request did not negatively affect planned services or deliverables. That's why they got all approved. And that takes us to the end. The proposed resolution is that the Legal Services Trust Fund Commission, Grant Eligibility and Support Committee approve the 2026 Quarter 1 budget modification request described in Table 1 of staff memo dated May 21, 2026. And I'm happy to answer any questions.
All right, great. Thank you, Esteban. Do we have any questions or comments?
I'm happy to make the motion if we're ready.
Okay, we have a motion on the floor. Can I get a second?
I will second.
Okay, that's Connolly, then Gonzalez, and we'll do roll call.
Connolly,
Yes.
Gonzalez,
Yes.
King,
Yes.
Judge Clyde,
Yes.
Pryor,
Yes.
Stalker,
Yes.
Galkin.
Yes.
7 yeses, 0 nos, motion passes.
Excellent. Thanks again, Esteban.
Of course.
I believe you have the next one as well, which is approval of the late 2025 EAF and additional EAF grant carryover requests.
Correct. Just 1 second. Let me share my screen. All right. So I will now present item 406. Approval of late 2025 Equal Access Fund and additional EIF grant carryover requests. So the GS Committee Charter authorized the committee to review and approve late carryover requests for all grant programs. State Board Rule 3.686D1 allows staff to approve timely carryover requests up to and including 25% of the award. The LFTFC may approve requests exceeding 25% and in extraordinary circumstances requests of 50% or more. The deadline for both 2025 EIF and 2025 additional EIF carryover requests was November 21, 2025. Staff received five late carryover requests, 3 for the 2025 additional EIF grant and 2 for 2025 EIF. Staff recommends approval of all 5 requests. Table 1 begins with 3 of the requests. First, we have Elder Law and Advocacy. They are requesting to carry over approximately 54.9% of its 2025 additional EIF award. The funding was awarded after the first quarter, which left the organization with less time to identify and serve eligible clients. Staff views this delayed and disbursement as an extraordinary circumstance, supporting approval of a carryover above the 50%. Then we have Eviction Defense Collaborative. They are requesting to carry over approximately 22.8% of its 2025 EIF award. Staffing vacancies and retroactive city funder invoicing changes delayed spending for them. The positions are now filled and the carryover will support shelter client advocate salaries and continued service delivery. Then we have Family Violence Law Center, where they are requesting to carry over approximately 14.3% of its 2025 additional EIF award. Other funding cuts affected the organization, and the carryover will help maintain plan services and staffing levels for legal services to survivors. The remaining requests are from Inland Empire Latino Lawyers Association. For its 2025 EIF grant, ELA is requesting to carry over approximately 40.9% of the award. Significant staffing changes and the ED transition and organizational restructuring affected planned spending. The carryover will support 3 legal aid clinics and a temporary bilingual intake assistant. Ayala also submitted a request for its 2025 additional EIF grant with a carryover of approximately 22.3%. The same organizational changes affected spending under that award. With improved administrative capacity, Ayala expects to use the remaining funds to support clinic access and participation. Staff have reviewed the explanations and recommend approval of all the requests. Now take us to the proposed resolution. The proposed resolution is that the Legal Services Trust Fund Commission Grant Eligibility and Support Committee approve the late 2025 EIF, an additional EIF grant carryover request from Elder Law and Advocacy, Eviction Defense Collaborative, Family Violence Law Center, and Inland Empire Latino Lawyers Association, including the Elder Law and Advocacy request that exceeds 50% of its award. Again, I'm happy to answer any questions.
Erica.
Thanks. And maybe there's not a thing here, but is there like any extra standard for the fact that they're late? And like I know in audits there's has to be extraordinary circumstances. I just want to see if there's any or what the explanation is for why they're late versus the substance of the carryover.
No, I mean, like the explanation provided is normally the ones you're seeing there, and that's why we have seen a lot of like requests for additional EIF, mostly because it was late. We distribute that money later in the year, so that's most of the arguments they're using for this.
Sorry, but this is money from 2025?
Correct. Yes. Last year, yes. We had EIF and additional EIF last year. The deadline was November 21st. However, we have had issues with some of these grantees to spend down the grant on time. So that's why we are bringing them late for your approval.
Sorry, I guess I'm a little confused, and I apologize if I might just be misunderstanding. So the deadline to ask for the carryover was November 2025. Is that right?
Yes.
Okay. But these guys asked after November 2025.
Correct.
Okay. And so is that because of the nature of is it because of what the reasons for the carryover, or is this just like, could they not have known they needed to do the carryover before November 2025? And that's why they asked for it, or is there some other reason that they didn't ask for it before November?
Correct.
Or by November?
Correct. As I was mentioning earlier, I think the most of the times what they are telling us is because, for instance, for additional EAF, we distribute the money later in the year. They didn't realize that they were not going to be able to fully spend down the grant by December 31st. So that's why they're requesting this later, like meaning this year. And all the arguments they provided are, I mean, in the memo of why they're doing it later.
Okay.
It's not uncommon.
Got it. I mean,
I'll just say it's not uncommon because they have to close their books and sometimes they don't know if there's extra money. It's not ideal for us. That's why we try to set a deadline so that we can capture it. But it happens with programs.
Mm-hmm.
Okay, so I guess more generally, we don't have any sort of extra showing or anything that because they are late, because it is pretty common. Is that right?
It is not necessarily very common. I mean, it does happen, but again, it normally is as Duan is mentioning. The deadline we provide for grantees to submit carryovers is this November around mid-November. And a lot of times grantees will not know if they're actually going to be able to meet the 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 spend down the grant by December 31st. So, they sometimes fail on requesting a carryover. And that's why they request the carryover on a later date. But because it's later, that's why we bring it to you for approval because it's now after the deadline.
Let me jump in. I think Erica helped me out there. Erica, you're asking about if there's an extraordinary standard or something akin to that, and there is not. However, you can do what you want to do. You want to put a condition on it. You want us to send a letter to a board. Like we're happy to do, but there's not that type of standard.
I'm not necessarily saying that. I guess I was a little surprised, and maybe this is just the nature of when people close their books, but it's now like almost the end of May. And so I'm just surprised that carryover money from 2025 with a deadline in November, we're now addressing it not in like February, but in like May. And it just feels like kind of a fairly long delay. And then I don't remember the carryover. How long do they have to spend
June
it
30th,
down?
2020, additional 6 months or standard.
So it's only, you have identified something that's a little bit odd because yes, they literally only have like a month to.
Right, they have like a month to spend it down, right?
Spend it
And
down.
so what have they been, so is it just, have they been holding it between January and now because we haven't yet approved the carryover? And so now what happens?
If you approve it, then they'll have, it's not just a month, but if they have expenditures from January to the end of May, then we would capture in their expenditures report, they wouldn't have to return it. So they just don't know about it, right? So they haven't like maybe spent it confidently. But Esteban, the delay is that yes, they were late, but was part of the lateness us not processing, or did they come to us later?
They came to us later. Sometimes it gets triggered by us closing out the grants.
For these these organizations, like
correct, these organizations they came to us after the first GS committee meeting in January, and that's why we're bringing it this time.
So they submitted their request in January?
No, after the GS committee we had in January.
So sometime in like February or March?
Yeah.
I'm just trying to get a sense of like when they actually
they're
submitted the application.
Yeah, no worries. They probably all have different dates. I will have to double check the dates specifically. But they normally came to us either February, March, or April. I'm reading here from our team, from the fiscal team, that most of them did it on April mostly, also some of them in March.
April. Sorry, that feels like kind of long. I guess my bigger question is, does the fact that they didn't make the requests until March or April suggest any issues with their fiscal like accounting or anything the answer may be no. I'm not opposed to doing the carryover, but we have focused a lot on time and being diligent in some contexts. And so I just want to determine whether this, and I understand, Dwan, your point that like it happens and people close and we sort of set an aggressive timeline because that helps us. But like, is waiting until March or April, like, does that indicate anything? I don't know.
To respond to your question, I believe we normally do not have this type of so late request, if I'm being honest. It has happened specifically with additional EAF. Again, because it was we were supposed to do the payment of this grant at a certain time at the beginning of the last year, and we ended up doing it almost in May. So that's why we're kind of being a little bit more, trying to be more lax and open to allow for this request to happen. We did notify all grantees that this is a one-time exemption, and but it happened mostly when we started, again, as I mentioned, closing out the grants or checking expenditure reports proactively that we saw these issues, and then they decided, hey, if I have the possibility, can I submit a carryover request? We asked internally to staff, and it was approved for us to move forward with allowing them this one-time exception that to be this late. So that's why we decided to do it.
Can I jump in? Am I on? Can I jump in? So, you know, we don't feel strongly that you approve this. I mean, there actually are our own staff that asked whether we could deny it. We don't actually, the staff doesn't have authority to deny this, so we have to facilitate this to you. But if you all feel this is like egregious or you don't want to, you don't need to approve this motion.
I'm not saying I'm opposed to the motion. I'm just trying to sort of tease out whether there's any underlying issues that we should be thinking about.
I think it suggests in like failure of internal controls, fiscal. I think the pattern of lateness in of itself is concerning, but I don't think we should read more into it that it's a failure of like fiscal controls or internal controls. But I do think there is a fairness question here that I think like for us and our staff, that's probably something warranted if you wanted to discuss it. Again, it's not to us an indication of lack of internal controls.
Yeah, I guess I'm just saying, I know Selena and Nicole have their hands raised, so I'll just make this one point. You know, I look at like elder law and advocacy, and they say, well, the funding was awarded after the first quarter, but I assume that was the first quarter of 2025, which means that they had from, you know, like half a year at least to kind of start to anticipate. Anyway, as I said, I am generally like fine with carryovers. I'm just really surprised that we're dealing with it in May, at the end of May, and not sometime earlier, especially given that it's not like we only had a GES meeting in January, right? We've had one between January and now. So like in March. So that suggests we didn't.
We had the January and then we had May. We didn't have one in between. Unless somebody.
Oh, okay. Because I guess we had our in-person and full meeting in February. Okay. Well, then fair enough. Maybe that's just really the issue, but I'm just surprised. It just feels like pretty far into 2026.
It's very late. It's very late. We won't contest that. It's very late.
Okay. Anyway, I'll let Selena and Nicole make their points. Sorry.
Well, I would urge the committee to approve it for 4 very quick reasons. One is that these are relatively small amounts. It's not as if an organization had $1 million or several hundred thousands they hadn't spent. And so these are small amounts, and the organizations are likely counting on the ability, and they're likely spending the money right now. Because another reason is this has been allowed frequently in the past, these late carryover requests. It happens frequently with smaller organizations, and the state bar has routinely approved them. So some organizations may believe it is likely, and they're spending the money. The third reason is that with the timing of the books closing, to know in November, you're looking at your September numbers to see if you have spent enough. And they may have thought that they were going to spend it down by the end of December and didn't realize until they were working on their audit that they had not spent down those funds. Or they may have had to move around other grants based on other grants restrictions and use other grants to pay for stuff they thought they were going to bill to IOLTA, because IOLTA and Equal Access Fund are so flexible. And my other one is that the additional Equal Access Fund did come quite late, and a lot of organizations were unsure of how to spend that first. And the very last one is new EDs sometimes don't know. They don't know that they can carry it over, and they thought they couldn't spend it, and they thought they had to return it. And then State Bar staff said, "No, you can carry over." And then they're usually so grateful that I did not realize we had a carryover. And then they know from then on out they can do carryovers. So those are the reasons why I would urge you to support the proposed resolution. And mostly because these are small amounts, and I think you can communicate to these organizations. Look earlier on each year.
Nicole, did you want to?
Yeah, and I, as you know, do not have a vote and no dog in the game, but It's a little bit along the lines of what Selena was saying. I don't know. I'm learning all of this as we go along, so I don't know much about this organization. But one thing that I think um, can often it could be all the things Selena said. It's about process, and it may be that by that the time it took to identify that they needed to do this, and then go through whatever process they have on the ground of getting things approved. And it could be something like that that is more about how they work internally, that they would prefer to get it in at the right amount of time, but there might be something in their process that stretches it out. And then along with everything Selena said about assumptions they may be making. So just same thing that maybe it would be beneficial to do some follow-up communication that says, is there something about your internal process that maybe affected this that you want to keep in mind or that you want to keep an eye on. So I hope it's okay for me to share that. It's just based on the work that we do with our grants oversight and being a grantee of another organization and going through similar things with them. Thank you.
Erica?
Yeah, I'll just make a couple of points. All of that makes sense. I appreciate that the numbers are small. The percentages, for at least two of them, though, are pretty high, right? One is almost 55%, and one is almost 41%. So again, I understand the numbers are small. They're small organizations. It just, it seems these seem like kind of big percentages of the grant, and I would be advised that they do a better job of understanding kind of whether they're spending it down. The other thing I'll say is, Selena, you said that there's new EDs. Are any of these guys, these four, do they have a new ED?
Well, the Eviction Defense Collaborative had the issue. There was the death of their former ED. That was the
okay.
So not new, but
That's eviction defense.
And Esteban's
Okay.
notes
I was
say
curious.
Yes, it's EDC and ELA as well has a change of the ED transition. And if you see it, there is four requests, but two of those are from actually ELA. So they have the transition with the ED and as well of EDC. So that put us like in three of these requests from ED transitions. And I also wanted to add one thing. Logistically, we normally bring to you. We have deadlines, 4 deadlines throughout the year, and we bring to you whatever is bring to us by that deadline. So what you saw in January 27, I believe it was, the deadline was November 21st because holiday season, everything is in the middle. So that's our deadline. So that's what you saw there in January. Now that we are in May, you're seeing everything that we have received after that. So, I mean, most of these requests are mostly from this year, but logistically, that's how we manage what we bring before you. So that's why you also seeing a lot of these late requests happening right now.
I do want to quickly respond to kind of what Selena said. I think I do generally agree. Like, things happen, programs take a little bit of time to close their books. But, when we had a codification topic about submitting late things, that worker group did want to be a little bit generous around this. I will say though, meeting deadlines is really important to us. I mean, it's time consuming for our staff to have to process these late requests on top of so many compliance issues. So, I mean, I think needs to be a balancing act. And I will say, programs should not be spending it before we approve it. So that's that's just not right. And we can try to reset that. But if you know that's happening, Selena, that should not be happening because this is still a pending request and they should not be spending money before the commission has approved that. We have been generous, but that doesn't mean this is like just pro forma and that we will be approving everything. Like Erica said, these are large percentage, though maybe dollar amounts might not be large.
To quickly clarify my comment, not that they're spending these dollars, but they're doing work that is qualifying expenditures for which they may be using general operating or other dollars, and that they are hopeful that this money will come through and they'll be able to show the qualified expenditures for the past 2 quarters. Not that they are only using Google Access funds for this, because we do that as well. We know we have general ops, we know we have reserves, and we hope that something would be coming in. Although we're not IOLTA funded, but I am a small ED, so I understand the accounting issues.
And maybe, I guess, maybe more generally, one suggestion I have to our chair for next year, and the team is like, maybe we do need to put another GES somewhere in there, so that it isn't January and May, to kind of account for this issue. I don't know, but it just feels weird because I'm approving it now and then they have like, a month and a half. Anyway, I'm not opposed to approving it. I just had some concerns with the timing and all of this.
So if that's the end of discussion, do we have a motion for this resolution?
So moved.
I second.
We'll go ahead and do roll call.
Connolly? Connolly? I'll come back. Gonzalez?
Yes, although I abstain as to the Family Violence Law Center.
King?
Yes.
Judge Klein?
Yes.
Pryor?
Yes.
Stalker?
Yes.
Galkin?
Yes.
Connolly? Okay, we have 6 yeses, 0 nos. Motion passes.
Thank you.
That's the last item.
I think that's the last item. So I think with that, I think we're prepared to adjourn. I appreciate everyone's time. Staff, thank you so much for all your hard work on all the agenda items today. I really appreciate you, and I'll wish everyone a happy afternoon.
We'll see you at the commission.
Thank you.
Take care.